cross-examine her, and we'd want to cross-examine Miss Bethel, the victim of the assault, and other material witnesses. We acknowledge that Mr. Ingaldson has the right to attempt to establish that there are other verified acts, added Salemi, whether they be bad acts or criminal conduct that may have been committed by Mr. Anthony. But they must make their presentations in a proper way, in a way that is fair to Mr. Anthony, in a way that permits Mr. Anthony to dispute those allegations in conformity with due process by allowing Mr. Anthony to confront the evidence which Mr. Ingaldson says establishes his involvement in this sexual assault. Your Honor, stated Ingaldson, the courts have long recognized here, and it's well established, that hearsay evidence can be used at sentencing proceedings. The entire pre-sentence report is hearsay. Ingaldson admitted that he intended to argue that the court considered the Michelle Bethel incident when determining Anthony's sentence, but decried any attempt to force Michelle Bethel to testify. There's no reason to put the victim through this, he insisted. I'm not sure how old she is, probably 16 years old now. She was 12 at the time. To haul her up here and put her through it when she doesn't know anything because of the extent of her injuries and her condition? She doesn't recall anything of that night. There's no reason to put her through that, unless there's some reason to try and maybe punish her more. Ingaldson explained that Salemi only recently indicated that he wanted witnesses regarding the incident. I do have Debbie Heck standing by telephonically, he said, so Mr. Salemi would be able to cross-examine her. Sergeant Grimes, who had a chance to review not only the police reports but also meet with investigators in Twin Falls a year ago, would then testify, so I don't know how the court really wants to proceed at this time. But we're not talking about what Mr. Anthony's seventh-grade teacher thought about him, complained Salemi, or his activities outside the classroom. The state has come and said they intend to prove that he's been involved in other criminal activity of a very serious nature. Assuming that this information is sufficiently verified through police reports and affidavits, or statements to the police, once you reach that threshold that's sufficiently verified, if the defendant says, I deny that I was involved in that crime, and I want to call those witnesses who the district attorney is only referring to in some sort of summary fashion, the defendant has that right. Mr. Ingaldson is going to stand up and say Mr. Anthony committed a sexual assault, for which he's never been charged or convicted, Salemi argued. He's just going to get up there and say that, and then say what other people have told him about it. I want the witnesses here. I want Miss Bethel here so I can ask her, Miss Bethel, do you remember participating in a lineup where you were asked to try to pick out the perpetrator? Do you remember that you weren't able to do that? Buckaloo wanted no further delays. I spent a great deal of time trying this case, said the judge. He stands convicted of 3 counts of murder 1, sexual assault, and kidnapping, and I want to get him sentenced today. Then I would ask, Salemi responded, the court to rule that you grant my protective order regarding hearsay. I can't grant it in total, Buckaloo said. Mr. Ingaldson should have the right to call the police officers. If he can get Miss Heck on the phone and she says Mr. Anthony told me that he did these things to this alleged victim, I want Miss Heck here, insisted Salemi. If she can be on the telephone, she can be here. The U.S. Supreme Court interpretation is that confrontation involves a person being here. So not only do we hear what she or he has to say, but also we get to observe their demeanor. And the court would be in a position to do that. I just don't want the state to put on a bunch of hearsay statements, speculation, and innuendo that could affect this court's decision. I just want both sides to be bound by the rules. Ingaldson, pegging Salemi's argument as simply delaying the inevitable, said, the courts don't require a person to confront witnesses at sentencing. What I suggest to the court, since this is all information in front of the court anyway, is that I am allowed to give a brief offer of proof and to see if there's any dispute other than Miss Heck's testimony as to the facts. It's my understanding that most of these facts are verified and admitted by Mr. Anthony. What I'm telling you now is information that Mr. Anthony admitted to detectives in Twin Falls, Idaho." "Admitted what?" asked Buckaloo. "I object," interrupted Salemi. "You know what happens. He makes this speech about what he thinks he knows or what people have told him. You hear it and then you say, well, I can't consider that. He'll have had his say, and we have not been able to confront or cross-examine the witnesses, and you're left with the impression that what he says very well might be true, and we're denied the opportunity to dispute that. So I don't think this offer of proof is proper or needed. In fact, I don't know why we're going through this, because as the court says, Mr. Anthony sits here convicted of very serious crimes. And what effect is the fact that he's a suspect and never been charged? What effect is that going to have on this case? I think the court can probably just rule that he not be allowed to go into it. My problem with that Idaho thing, said Buckaloo, is that if they had all this evidence, why didn't some grand jury indict him? Why didn't they try him? Kirby Anthony suddenly stood up and said, "Your Honor, if I may offer of proof myself—" "No, don't interrupt me," snapped the judge. "Don't interrupt me. You may sit down. I just don't want to waste a lot of time. If you really want to pursue it, I think I'm faced with a possibility of having to continue the sentencing and let you get your witnesses up here and, well, we don't know that, Judge," Ingleson said, "because we're arguing in a black morass now. You don't even know what the offer of proof is or what the evidence is. Maybe you'll consider it not important. Mr. Salemi, in his most recent argument, had indicated that he thinks that this is not even necessary to this sentencing. That may be. If the court feels comfortable going forward with the sentencing without knowing about this, if you feel that it is a waste of time, then I won't go forward with it. But I would certainly want to preserve my opportunity in case people upstairs disagree." "Mr. Anthony is requesting to say something, Your Honor," stated Salemi. Judge Buckaloo cast a tired eye at the handcuffed defendant. "Oh, all right." "I apologize for interrupting, Your Honor," said the convicted murderer. "I'm going to try to be as contrite as possible on these issues. I agree with Mr. Salemi, and I agree with the court that this is an academic issue, and it's kind of pathetic in itself. I'd just like to tell you, Your Honor, if you give me any less than the maximum sentence, excuse me if I take it a little bit personal, I don't have any objections to Mr. Ingleson bringing any witnesses in on these issues at all, or any evidence, but I want the right to dispute it. He's made accusations that I'm involved in other crimes that I have not been involved in, and I have evidence to prove that I have not been involved in. But I don't have all of it, and the reason why is because I haven't received it from the district attorney's office here, or the police in Twin Falls, Idaho, which in those regards has to have a continuance because I cannot present myself in a proper manner because I don't have all the information. But the information I do have says that I'm not involved in it, Your Honor. But again, as I said, I'm not arguing. In fact, I expect the maximum sentence, and if you didn't give the bastard who did it—" Buckaloo, fed up, cut him off. "I think I should be candid with you," said the judge sternly. "I agree with the jury's verdict. There is no doubt in my mind that the jury reached the right verdict." "I don't need a speech to the media," said Anthony, mimicking Salemi's earlier remark to Judge Rowland. "I understand your feelings. I understood it from before this trial started." The judge ignored Anthony, turned to Ingleson and said, "All right, what's your offer of proof?" As Ingleson began speaking, Anthony broke in. "Excuse me, Your Honor, for interrupting one more time. Is he getting ready to make an offer of proof on these crimes that I'm alleged to have been involved in? If he is, Your Honor, what I have just said is that I would request that the witnesses be pulled in so I have a chance to rebut, and that I be allowed to have any information that was involved in this case, which I do not have. from the police officers investigating the Twin Falls crime, or from what the police or the investigation has here in Anchorage. Ingleson and Buckaloo ignored Anthony's repetitive rant. The prosecution continued his offer of proof. On that day, in 1985, June 26th, there was a party that was held at an area in Twin Falls. There was a ravine by this area, a common area for parties. A 12-year-old girl was there. Mr. Anthony had been seen with that girl earlier in the night, as other people had been. The girl was found later the next day. She was severely beaten, has permanent eye and ear damage. In fact, I have photographs of her injuries if the court decides to consider this information. She has suffered permanent injuries because of that still exist to this day. She was left for dead down by a creek, a ways away from where there was a bonfire. Mr. Anthony was at that party. Some thongs that belonged to Mr. Anthony, or at least that he was wearing that night, were found near the body. Ingleson related Anthony's peculiar explanation of why his thongs were at the crime scene and informed Buckaloo that there was little or no forensic evidence from the scene and that the girl was so damaged that she was unable to identify her assailant. The police did go get clothing from Mr. Anthony, continued Ingleson. And here's the part that the people in Twin Falls are not aware of that came to light when Miss Heck informed us that when the police came the next day to get clothing and things from people who were at the scene, that Mr. Anthony gave him different clothes other than what he was actually wearing. In fact, she saw his clothes and saw a pair of pants he was wearing that night. Mr. Anthony told her that he tore the pants at the party and that he was going to throw them away, that she shouldn't say anything about it. She also said she saw stains on the pants that could be mud or blood. So, essentially, that's our offer of proof concerning that incident, and it's my understanding that with the exception of Miss Heck, since Mr. Anthony has essentially admitted the rest of the offer of proof, I don't think there is really a dispute except for Miss Heck's testimony. I've heard those facts before, Buckaloo said, and it sounds like it was an outrageous offense. I don't know why it wasn't vigorously prosecuted, and every decision I make is going to be reviewed by an appellate court. I'm just a little skeptical of letting you use it unless you get the witnesses up. I don't know why it wasn't prosecuted either, admitted Ingleson. I do know that Mr. Anthony came to Alaska a short time after that. Perhaps that's the reason, since he was out of state. Ingleson explained that he hadn't had time to bring witnesses to the current hearing and that money was also an issue. In fact, I had originally intended to bring an investigator from Twin Falls, but I guess in light of statewide concern for money being spent on things and in light of whether it was actually needed, I don't have those witnesses now. I think it is more important, he said, to go forward with the sentencing not only for the community of Anchorage, but also, I think, for the victims and friends and family of John Newman and Cheryl Chapman, who I have spoken to. I know what they went through when the case was continued last time in sentencing. Salemi and Ingleson cooperated on procedural issues prior to the sentencing hearing, but Ingleson wasn't aware until that day in court that if the case were remanded by the Court of Appeals, the state would still have an opportunity to present the Twin Falls sexual assault information. Once he understood that he was not waiving the state's ability to do so, he acquiesced. I was offering that agreement before the court ruled, Salemi chided, hoping that Mr. Ingleson would withdraw his need to make this offer. But he went ahead, and the court has essentially ruled. I don't see there being any agreement, but I also feel this doesn't matter, whether we have an agreement or not. The issue is either preserved or not. He's made the offer of proof, so I don't see that as being an issue. Well, observed Buckaloo judiciously, when two persons have both graduated from law school, it makes it difficult to get an understanding between the parties. It's my understanding from your remarks, said Salemi, that you're not going to consider the Twin Falls sexual assault as having any impact on the sentence. Is that correct? "I've already indicated I have concern about why nothing was done about it," answered the judge. "He has the presumption of innocence as far as I'm concerned." "And the court would consider him innocent?" asked Salemi, "even though it's heard certain representations?" "Presumed to be," clarified Buckaloo, drawing a distinction between presumes and considers. "I said I can presume that he's innocent of that. Do we have any other skirmishes we have to resolve before we get started?" "There was no skirmish about Napagack, of course," said Grimes later. "I believe we could have charged Anthony with the Napagack murder, and the only reason we didn't was to save the state money. As Anthony was already convicted of the Newman homicides, there was no reason to pursue it at the time." Ingleson, in retrospect, disagreed. "I don't know if we could have built a strong enough case against Anthony in the car wash murder. Possibly, but I wouldn't want to risk it. Besides, when sentencing day came, I knew Anthony would be put away for quite a while." Anthony was belligerent one minute and whining the next, repeatedly interrupted the judge and argued with his defense attorney, John Salemi. Together, however, they made significant efforts to minimize the unpleasant aspects of Anthony's pre-sentence report. The more aggravators, the higher the sentence. "Aggravating circumstances involve a person's criminal history," explained Salemi. "Mr. Ingleson, as the state's representative, alleges with respect to a criminal record is one conviction for robbery when Mr. Anthony was 18 or 19 years old. I don't think that's sufficient to establish a repeated source of that type of aggravated conduct. I ask the court to find that one hasn't been established." Ingleson wanted Anthony's domestic violence history taken into consideration. "I would ask the court to also consider," he said, "the statements made by other girlfriends of Mr. Anthony, that he had in fact choked them on several occasions, and their fear of him because of his physical abuse, specifically Kim Atkinson and I believe Miss Mendenhall." "The domestic dispute was investigated by police," countered Salemi. "I think Mr. Anthony was arrested, and then that case was dismissed by authority. I don't think that should be considered." Buckaloo, not surprisingly, agreed with Ingleson. "I find enough on the record to support that aggravator by clear and convincing evidence." Anthony wanted to minimize all his juvenile criminal activity, including his 1978 first-degree burglary. "He thought it would be important for the court to know the circumstances," explained Salemi. "Anthony's first crime was breaking into the school commissary and stealing candy. I believe other young people with him walked in, and going through an open window took and consumed some candy." Salemi, who insisted that it was not properly characterized as a bomb, confronted the allegation that Anthony bombed a building with a balloon. It involved a balloon with some oxyacetylene in it from a welding tank, and he was only secondarily involved in it. I think he was partly the person who hatched the plot, but his intention was to set it off in an open field. He was not near the balloon when it was actually detonated. It was his friend's idea to put it near a building. Courtroom spectators found these clarifications and revisions most peculiar. Anthony was about to be sentenced for 3 counts of murder 1, 3 sexual assaults, and 1 charge of kidnapping, and he wanted to explain whose idea it was to put a balloon bomb next to a building a decade earlier. Anthony was most upset over a comment in the report attributed to his brother, Michael, that Anthony almost hit his mother in the head with a wooden statue during one of his temper tantrums. "Mr. Anthony denies that he ever engaged in that kind of conduct," insisted Salemi. "He has a letter which he gave to me last night from his mother. I would like to present it to the court. The court would probably take 30 seconds in reading it. I would like to incorporate it as part of the record, Your Honor." The letter, handwritten by Peggy Anthony on September 27, 1988, was both clear and emphatic. She made no mention of the rape and murder charges, but expressed concern over remarks attributed to her other son, Michael, on September 14, 1987. According to Grimes and Spatafora, Michael Anthony told them that Kirby once tried to strike his mother in the head with a large wooden statue. Peggy Anthony insisted that the alleged statue incident was a lie, and that she would swear under oath that Kirby Anthony never raised a hand to her. The vicious things said by her family, brothers, and sisters were lies, too. She told the court that Kirby was always polite and respectful to his relatives. Because of these lies, Peggy Anthony said her family didn't have the guts to face her. Page 10 of the pre-sentence report featured a summary of information provided by Kim Hawkins Atkinson. Questioned extensively by police, she didn't testify at the trial. Pregnant with her third child, she didn't need the stress of a court appearance. Mr. Anthony denies he ever expressly or impliedly threatened Miss Atkinson, Salemi said. In fact, in her statement, which we received from the district attorney, she said she believed that Mr. Anthony would never hurt her. Kim said that so she wouldn't have to testify in Alaska, confirmed her mother. The only way to get out of it was to make conflicting statements. She was actually advised to do that, as to be exempt from going up there. We were very concerned about her health during that pregnancy, and they had enough on him that my daughter wasn't vital to the prosecution. The report also referenced Anthony's drug and alcohol use, noting that youth service center tests revealed an alcohol problem. It also quoted him as saying he used marijuana and LSD to relax. Mr. Anthony denies having an alcohol problem, said Salemi, and he has never used LSD to relax. Mr. Anthony also disputes the pre-sentence worker's evaluation. Probation officer Joe McDowell, the assigned pre-sentence worker, submitted the following evaluation of Kirby D. Anthony. Mr. Anthony exhibits behavior patterns which are similar to those of anger rapists, with cyclical patterns culminating in physical and/or sexual abuse. Poetry that Mr. Anthony wrote indicates he recognized a buildup of feelings that lead to violent behavior. These offenses were, without doubt, the most heinous and vicious attacks this officer has ever encountered. The victims died agonizing deaths and must have experienced absolute terror before their demise. Mr. Anthony has proven many times over that he is a danger to society and should never be released. Mr. Anthony, insisted Salemi, denies that there is any history of sexual assault with respect to his personal experience, and feels that this is an inappropriate evaluation. There is no evidence to show that Miss McDowell has any particular training or education with respect to what are obviously psychological issues and particular profile type of findings. We think her statements are inappropriate and ask the court not consider her sentiments that Mr. Anthony may be what's termed an anger rapist. You have your objection on the record, noted Buckaloo. He then turned to the prosecutor. All right, Mr. Ingleson, I'll hear from you. This was the home stretch. The state already won the case, but complete victory means maximum sentencing. Bill Ingleson, well prepared as always, stood and delivered. In preparing for sentencing, the events of what happened about a year and a half ago certainly came flooding back to me, and I'm sure everyone in this courtroom. People will probably not ever be able to put it out of their minds. I think without a doubt it's among, as Miss McDowell points out in her comments, the most aggravated, the most heinous murders ever experienced in Anchorage and Alaska in modern times. If you look at the facts of this case alone and consider only the facts of this case in order to reaffirm society's norms, and in order to give a feeling of the justice system having the ability to work at all, I think this court is compelled to give the maximum sentence on each count. The facts alone cry out for that type of sentence, and really, there is no sentence that will ever atone for what happened. Angie Newman, a 2-year-old girl who was just blossoming into life, she won't be brought back. Melissa Newman, who was 8 years old at the time, was just going through kind of the awkward stage as a young girl. Her life can't be brought back. Nancy Newman, the joys she would experience as a mother. That can't be brought back. And I don't think any type of punishment this court can give will adequately avenge or reflect the pain and suffering that they went through when this happened. Because this wasn't just a loss, a simple loss of life of 3 persons. Judge Buckalew stopped Ingleson's presentation by saying, "I think for the record I should caution you that I cannot consider revenge as a factor. That's not one of the things that I can consider." "I'm not saying revenge," Ingleson clarified. "You can't consider that and shouldn't consider that. But I think the goals of sentencing are many. There are 5 recognizable goals, and 2 of them I would ask the court to base its decision and place greatest emphasis on are those of community condemnation, reaffirmation of societal norms, and isolation of Kirby Anthony. When this incident happened, there was a great deal of pain, suffering, and terror that's certainly unimaginable. Just hearing the evidence at trial, observing the photographs of what happened, I think this court is well aware of what went on. But we have even more than that in this case. We have a person who has a history that maybe some psychiatrist would say that this type of behavior might even have been predicted. We don't have a psychological report. On behalf of the state, I did request a psychological evaluation. I think case law indicates that the court, if possible, should consider a psychological evaluation. But Mr. Anthony does have the right to refuse that, a Fifth Amendment right to refuse that. He did refuse through motion of his attorney and later indicated that he was going to get a psychological examination. Of course, we haven't seen that. If you gauge the community's reaction to this type of crime, reasoned Ingleson, I suppose there are probably members of the community that say even the maximum sentence isn't enough. And that seems to be the indication of John Newman in his letter, and Cheryl Chapman in her letter to the court. So I guess I would ask the court to do as much as it can. I've tried a lot of cases in front of Your Honor, a lot of real serious and awful murder trials, said Ingleson. This court has heard many, not only that I've tried, but many people have tried. And I'm sure that the court probably cannot recall a worse murder than this case. Mr. Anthony, since the time he was very young, was involved in violations with the law. He certainly didn't have the greatest childhood. His father was not particularly kind to him and his siblings. But we know of many other people with a similar situation who turn out fine. That's certainly not an excuse. Maybe it's one fact that would help predict what happened. If you look into the junior high age, explained Ingleson, you see someone who, according to intelligence test, is a bright person. You saw him in court, and certainly he's not a fool. He's not someone who lacks mental capacities. But he nonetheless failed scholastically. He was an underachiever in school, had a high number of truancies, and eventually quit school at a young age to begin what has been a consistent pattern of criminal activity. Starting with burglaries, progressing to throwing a balloon type of bomb into a building, which I believe was a school, committing an aggravated robbery where a woman was confined to a wheelchair. After stealing from her, he sprays her in the face with mace, indicating intentional cruelty. His relationships with girlfriends is one of violence. According to Debbie Heck and Kim Atkinson, there was physical abuse. Even when he was in jail, when you think someone would be on their best behavior while this case is pending, if you look at the pre-sentence report concerning his activities in jail, you will see it's replete with a dozen different violations involving assaultive conduct. 2 of them are particularly egregious. One of them, in December of 1987, the victim had to go through several hours of surgery. The victim of that, Travis Murphy, wrote me a letter wanting this case prosecuted, and I explained to him that the way we would handle it is for the court to consider it at sentencing. I don't know if the letter is attached to the pre-sentencing report. If not, I'd like to include it. Travis Murphy's letter to the district attorney's office in general, and Ingaldson in particular, was received by Buckalew on August 9, 1988, and included in court records. On a number of occasions, explained Murphy, he tried to press charges against Anthony. State troopers visited him twice about this, and on both occasions told him that they did not want anything interfering with the charges for which Anthony was being prosecuted. On December 16, 1987, Anthony struck Murphy on the right side of the head with his elbow, causing severe nerve damage and broken bones. This was, according to Murphy, an unprovoked assault. At the time he wrote the letter, Murphy already had 4.5 hours of surgery because of this assault, and was scheduled for more in the near future. Well aware that Anthony faced a lot of time from his previous charges, Murphy didn't think that should have anything to do with the charges he wanted to file. Another issue Ingaldson addressed was the possibility, albeit remote, that Anthony would derive income from a proposed book about the crime. I guess he tried to get some writer to take up his cause, said Grimes. The thought of Anthony making a dime off homicides and sexual assault was, of course, completely repugnant, especially to John Newman and Cheryl Chapman. Ingaldson asked Buckalew to rule that all of the royalties or other compensation be forfeited and turned over to a victim's fund. I don't know if the court can specifically rule where it be turned to, but that court ruled that Mr. Anthony must turn that money over to the state to be applied to a victim's group. Thank you. Before Buckalew concluded the pre-sentence hearing, Salemi made preparatory remarks, followed by his final plea. My first instinct, Your Honor, began Salemi, would be to argue some of the factual issues of the trial, and hope that the court might agree with me that the state in some manner had failed in its proof. But I know the court has, first of all, commented on its belief regarding the jury's verdict. And secondly, I know by doing that I would be avoiding the cruel reality of why we are here today. I remember back in the middle of the trial, perhaps one of the low moments, the court looked down from the bench while the jury was out, fortunately, and said something about Mr. Anthony looking scary or intimidating. Did I do that? Asked the judge. Salemi didn't answer. I just wanted to say, Salemi continued, that except for perhaps today, when Mr. Anthony has been a little bit jumpy, and understandably so, in my mind, he has been polite. He's acted in conformity with how I would expect him to. He's been non-threatening to me in his demeanor. He's a very intelligent man. Well, responded Buckalew, I haven't really felt threatened by Mr. Anthony. He hasn't been disrespectful to this court, although he disagrees with this court's conclusion that the jury reached the proper decision. I can understand his position, but I disagree with him. Having made his preliminary remarks, John Salemi pleaded for mercy on behalf of Kirby Anthony. I know that this court has two major objectives to consider, he said. One is protection of the public, and the other is the reformation of the individual. Both are to be given serious consideration. I can't, you can't, no one here would ignore the nature of these crimes and the immensity of them. I'm aware of the number of years that you have at your disposal with respect to the sentence you will give Mr. Anthony. I would ask only that the court consider that Mr. Anthony is a man who is only in his 20s, who, if indeed he committed these crimes, he's profoundly disturbed, profoundly ill, and must be pitied, and must be helped if we're an enlightened society. There is no way this court can anticipate what or who Mr. Anthony would be 5, 10, 20, 40 years from now. To try to speculate who Mr. Anthony will be at 40 or 60 or 65, what he will be like would be impossible for this court. To know what he'll be like and what place he should have in society after a lifetime of punishment, when you and I are probably even no longer around, is too difficult to fathom. I guess what I'm suggesting, continued Salemi, is that when that time comes, shouldn't the court at least put some other person in a position so that other person has the discretion to recognize that there perhaps has been a profound change in Mr. Anthony, to recognize the indomitability of the human spirit, and to give Mr. Anthony a glimmer of hope? I would ask the court to consider fashioning a sentence that also forwards the objective of the reformation of Mr. Anthony, and without some hope on the part of Mr. Anthony that he can lead a different life, maybe if it's only in his last years. Reformation cannot be achieved, and there will be no incentive for it. As human beings, we try to temper justice with mercy, and even in these grave circumstances, we as human beings try to be merciful and forgiving. Salemi asked Buckaloo to run all sentences concurrently, giving Anthony 33 years until eligible for parole. People do not choose in any meaningful way to go out and commit these kind of crimes. It has to do with some profound disturbance over which they have little control. Those conclude my remarks, unless the court has question. The pre-sentence hearing concluded. Buckaloo called a 10-minute recess. When court reconvened for final sentencing, the brash confidence Anthony displayed during his dramatic trial had long since dissipated. Handcuffed at the wrists and chained at the ankles, Kirby D. Anthony launched verbal tirades against the reputation and integrity of prosecutor Bill Ingaldson and defense attorney John Salemi. "I was going to ask for continuance today," said Anthony. "And again, there's been a lot of academic issues raised here, and I feel it's inappropriate. I don't oppose the sentence, even if it was the maximum. I don't oppose it if it was 1,000 years. And the reason why, Your Honor, is because I know I'm innocent, and I know one of these days, those back doors over there, I'll walk out, and I'll be free. Mr. Salemi made some suggestion that I'm an intelligent person and not a fool, as well as the prosecution. There's no possibility that anybody who did this could be sane." "Well, Mr. Anthony," commented Buckaloo, "you know the court's position. I've already made it abundantly clear to you that I agree with that verdict." "You did that before the trial even started," countered Anthony. "I was aware of that. That's what prejudice is all about, Your Honor. On some of the actions that Mr. Ingaldson has accused me of through Cook Inlet pretrial, one of them such as Mr. Murphy, Mr. Ingaldson, he's not too interested in the truth and relating to the court that I was found not guilty on that. I agree that the man was injured, but as I've said, Mr. Ingaldson is not interested in the truth. If he was, he would have investigated further and found out what the disposition is on the Cook Inlet pretrial record, and he hasn't done anything. But there's been numerous instances of that, and I won't go into them." "Again," repeated Anthony, "I feel the sentence should be the maximum, and the reason why, it's not because I am guilty. It's because if you give the person, the perpetrator who actually did this, anything but the maximum, I would haunt you to your grave, Your Honor. There's been an issue raised about a book that's being produced, and Mr. Ingaldson seems to think or hear rumors that I want to profit from this. The author and I have agreed, and it was my suggestion and my wishes that I not profit from this, and it was the furthest thing from my mind. And between the two of us, the writer and myself, there is being papers drawn up for the purpose of me signing over anything for capital gains at all. The purpose for the book is to show the public for what it is exactly involved in this case, period. And that's all." Buckaloo would not concern himself with publishing agreements. "I don't think I'm going to address that issue in the sentencing." Anthony then complained bitterly to Judge Buckaloo that he had not received photocopies promised by the public defender's office. "If I could comment briefly, Your Honor," requested Salemi. "Doing the copying for Mr. Anthony has not been a real priority of mine, especially when it's materials I've already given him more than once. Now, we do have notes and cross-examination questions that we didn't provide him. We'll do that, and I'll get around to it. And Mr. Anthony will get all of that information prior to the notice of appeal being filed. It's true that Mr. Anthony has requested this on numerous occasions. We've tried to accommodate him where we could, but we weren't able to do that in the time in which he wanted it done. Anthony quickly added additional commentary. He says it's not a priority of his. He says he has 6 boxes. He says now that it's less than 6, which I probably agree with him. He's just dramatizing to the court. He's trying to insinuate how much it is. What is his priority toward me? What are his obligations toward the client? And that's to show the client everything that's involved in this case. Why haven't I received it? How come it's not in my hands right now? How come it wasn't in my hands before the trial started? Your Honor, I tried 3 months politely asking. Buckaloo cut him off. All right, I'm going to do sentencing. Mr. Salemi, I'll require you to remain standing and Mr. Anthony to remain standing during the sentencing. I have a few preliminary comments I want to make to Mr. Anthony. First off, we're not trying Mr. Ingaldson here today. I will, Your Honor, Anthony asserted. We're not here, but I will. But because of your comments, continued Buckaloo, and it's not going to affect my sentencing. I didn't expect it to, Your Honor, Anthony interrupted. I didn't mean to interrupt you. I just like to fill in the gaps. Buckaloo paused, took a breath, and continued. I want to put this on the record, he said, that Mr. Ingaldson has been in my court many, many times. He's made representations to this court on all kinds of matters. He's been candid, truthful, honorable, and I just wanted to get that matter out of the way. Well, barked Anthony, can I put something on the record, Your Honor? I'd like to know where he went wrong, because he lied, and I'll prove it. Buckaloo, neither amused nor impressed, simply said, Now I'm going to go ahead with the sentencing. I'm required to impose just sentencing in these matters, and I intend to impose what I consider to be a just sentence. Mr. Ingaldson is not interested in the truth, said Anthony. He wants to assert anything that's negative to the courts, and I don't even know why I'm standing here to try to justify all this BS, because I don't know why you are either, interrupted the judge. These murders, and we have 3 murders, 2 first-degree sexual assaults, and a kidnapping, are the most egregious cases that I've ever had contact with. 2 of the victims are children so young that they couldn't have committed any kind of grievance against anyone. Counsel and this court and the jury had to look at little Melissa's picture, what the body looked like, the terror you could see on her face. It's almost like killing an angel. That's what it is, agreed Anthony. Buckaloo glared at the defendant, and his voice became steel on chilled steel. This court had to look at those pictures, and this court is never going to forget that picture. This court is of the opinion that you're the person that did it. This court had more evidence than the jury had. It's a terrible, terrible crime. Count 1, Count 2, and Count 3 are the homicide cases. On Count 1, I sentence you to 99 years. On Count 2, I sentence you to 99 years. On Count 3, I sentence you to 99 years. Those 3 counts run consecutive with each other. The judge then turned his attention to Count 4, the kidnapping charge. I don't think the facts and circumstances would justify a consecutive sentence to the homicide and the facts surrounding the restraint. On Count 4, I sentence you to 99 years, but Counts 3 and 4 are to run concurrently with each other. Count 5, is the first-degree sexual assault of little Melissa. I've already indicated it's the most aggravated and obscene conduct. I've found the aggravator. I believe this sexual assault deserves the maximum penalty of 30 years. I sentence you to 30 years. Count 5 is to run consecutive to the other counts, and the sexual assault on Melissa's mother and your aunt, again, it's the most outrageous conduct. I sentence you to the maximum sentence of 30 years. Count 6 to run consecutive to count 5. Because of the length of the sentence, it's doubtful as to whether you'll ever take another breath as a free man. I'm going to follow Mr. Salemi's recommendation that I don't restrict parole. I'm going to leave that up to the parole authorities. If it's ever an issue, and I doubt that it will ever be an issue, but Mr. Anthony, our Constitution, when addressing what should be considered in the criminal law, they only mention two things: rehabilitation and the protection of the public. I have no reservation at all in stating that from what I've heard in this courtroom, that you're probably the most dangerous offender that's ever been in my courtroom. And the victims in this case, the children— "I don't need to hear this," yelled Anthony. "I have already been sentenced. That's all I need to know. What are you going to do? Put me in jail? Because I don't want to hear what you have to say to the media. Save it for them, Your Honor. I don't need to hear it. I'm innocent, and I do not need to be ridiculed and persecuted." Buckaloo, incensed, turned to John Salemi, saying, "Counsel, I'm not going to have him—" "I'm through with the courts, Your Honor," interrupted Anthony. "I don't need to be persecuted." Then to Salemi, Anthony said, "He's already made the sentencing. I don't need to hear his speech." Salemi tried to calm him down, encouraging him to curb his outburst. "He needs to make remarks," explained Salemi. "That's—" "Then give it to the media," Anthony yelled, "because I don't need to hear that, and I'm sorry if I'm upset." "That protects you also," continued Salemi, putting his hand on Anthony's shoulder. "Get off me!" snapped Anthony. Judge Buckaloo had heard more than enough. "Counsel, I'm not going to have him gagged or make more comments. This court is in recess." Kirby D. Anthony, shackled, unrepentant, obstinate, and angry, promised a press conference during which he would detail the lies and misrepresentations of those who conspired against him. When he erupted in the courtroom, recalled Grimes, it was the same selfish rage that fueled his cruelty toward the Newmans. It had not lessened, nor was there the slightest hint of shame on his part. Under Buckaloo's sentencing, Kirby Anthony wouldn't even be eligible for parole for about 120 years. No cathartic resolution accompanied the sentencing of Kirby Anthony. No release from the pain, terror, and haunting nightmares for those who knew and loved Nancy, Angie, and Melissa Newman. There is nothing that can erase what happened. No way to return Nancy to John. No miracle that would result in the Newman children healthy and happy leaping into their daddy's arms, lamented Grimes. As professionals, we're proud of the job we did on this case. I hate to think how many other people would be dead by now if he hadn't been stopped. What if Kirby Anthony had made it across the border? What if he eluded capture? What if he kept moving, kept killing, continued his sexually charged, rage-filled rampages? How many raped and murdered children? How many broken-hearted parents? How many grieved family members? How many lives cut short by one selfish man's anger and lust? If Anthony had not killed the Newmans, he would have killed someone else. It was only a matter of time. Perhaps the Chapmans, maybe Debbie Heck. If he suddenly decided that he wanted sex with Kirk Mullen's girlfriend and she rejected him, he could have killed her and Kirk. We don't know who he would have killed, and I don't think to him it much mattered. After all, if he could rape and murder his own family members, he would not be deterred from doing anything. Besides, look at Anthony's history. From adolescence on, he robbed, raped, and killed. While the typical criminal career is relatively short, Dr. Hare has noted there are individuals who devote most of their adolescent and adult life to delinquent and criminal acts. Many of these career criminals become less grossly antisocial in middle age, and about half of the criminal psychopaths studied show a sharp reduction in criminality around 35 or 40, but mostly in respect to nonviolent crime. Their propensity for violence, however, appears to remain constant and persistent. Hare was quick to point out that just because these individuals may seem to mellow with age, this doesn't mean that they suddenly become warm, caring, loving, moral citizens. Most remain thoroughly disagreeable individuals. They may alter their antisocial behavior, but they retain the callous, manipulative, and egocentric traits of psychopathy. Entitled to an appeal, Anthony harassed his new court-appointed attorney, Rex Butler. Butler did not seek out Anthony's case, nor was he particularly delighted to have it. Nobody wanted the damn thing, confirmed Butler, who was hired by Brant McGee, head of the State Office of Public Advocacy. The point of an appeal is to decide if a trial was legal and fair, not to rehash the evidence or second-guess the jury, explained McGee. Just because evidence is complicated doesn't mean the law is complicated. After 3 years enduring Kirby D. Anthony as a client, Rex Butler asked the State Court of Appeals to reassign the case to another attorney who can devote the time to it that it undoubtedly deserves, and one who won't have to endure his rudeness, threats, and irrational behavior. Butler said that Anthony threatened him for not devoting enough time to his case. He sought to set the priorities for his case and my office, he elaborated, and to threaten our office staff by telling them to tell me that Butler's going to be sorry. Anthony, again acting as his own co-counsel, launched a separate claim for a new trial based on his assertion that Salemi and Howard did not do a good job. Convicted felons routinely file so-called ineffectual assistance of counsel claims, explained Grimes, but the fact that Anthony was his own co-counsel rather undermined that approach. Plus, I recall Judge Buckaloo telling Anthony that he couldn't have got a better defense if he had paid Salemi $2 million. In 1991, 3 years following conviction, Anthony's appeal was still in its early stages. The basic brief explaining what was unfair about his trial was not yet filed. One problem, according to Butler's office, was the immense volume of paperwork generated by the trial. 54 volumes of transcripts, plus hundreds of pages of police reports and expert analysis. Butler stated that Anthony intended challenging the admissibility of so-called genetic fingerprinting evidence used against him, and would also claim that John Salemi failed to introduce evidence that Anthony insisted could clear him of all charges. If such evidence actually existed, asked Grimes, why didn't Anthony present it during his trial? After all, he was co-counsel and was obviously calling the shots. And would one believe for a moment that Salemi would withhold evidence that would clear his client? Aside from the overwhelming amounts of trial testimony and evidence, Butler also faced financial problems. A complete investigation of the case, including paid defense experts testifying that the prosecution's experts were in error, could cost up to $50,000, more than any previous case in the history of Alaska's Office of Public Advocacy. This is the equivalent of a capital case, said Butler, explaining the enormity of the situation. He's got a sentence that means he'll die in prison. The State Court of Appeals denied Butler's request for removal and offered no explanation for its decision. Anthony wants a lawyer who will spend 8 to 10 hours a day, 5 days a week, on just his case, said Butler. If I was standing in Kirby Anthony's shoes, realistically, I'd probably be just as upset as he is. I don't think it's really personal. Butler followed through, preparing and presenting Anthony's appeal to the Alaska Court of Appeals. Requesting a new trial, Butler argued that the allotyping blood tests utilized by the prosecution were not widely accepted by the scientific community, and the testing itself was flawed. There were also questions raised about the utilization of a private laboratory hired by the prosecution that conducted testing without defense in attendance, a point acknowledged by Ingaldson at the close of the trial. Private labs, however, fit into the caseload mix by helping to reduce state lab backlogs. They step in, for example, to help the prosecution ensure that a defendant obtains a constitutionally mandated speedy trial. An individual must be brought to trial within a certain period of time after having been charged in an arraignment. Many state labs are unable to finish the work and produce results in time for the prosecution. The argument against allotype test results used in court was severely weakened by the vast strides in forensic science in the years between the Newman homicides and Anthony's appeal. In 1989, 1 year after his conviction, only 3 laboratories, one at the FBI and 2 private labs, were performing DNA forensic analysis. Now, nearly a dozen private labs and about 50 state and local crime labs conduct the tests. Howard Coleman, president of GeneLex Corporation, a Seattle-based private biotech firm, said that the total annual caseload has grown to more than 10,000, 75% of which involve sexual assault. Genetic Design Incorporated, a public firm in Greensboro, North Carolina, reported that a large portion of their business was now database work. Genetic Design was contracted by the state of Alabama to analyze about 12,000 samples for the state's first DNA database. The database is intended to be used when there are crime scene samples but no suspect, much like a fingerprint database is used. 32 states passed laws to create similar databases, legislation made possible under the Federal Crime Bill of 1994. By 1995, when Alaska's Superior Court ruled on Anthony's appeal, there was no longer any question as to the acceptability of Shanfield's scientific tests. On October 27, 1995, Judge Mark Rowland concluded that the scientific theory upon which allotyping of blood and semen is based, as well as the databases, technology, practices, and procedures employed in carrying out the analysis upon which their opinions are based, are accepted by the relevant scientific community. Basically, Judge Rowland ruled that the blood typing evidence used in the trial was good science, said Grimes, and even if it wasn't, there was enough other evidence offered against Anthony for a jury to find him guilty. Anthony, however, was not giving up. His case could still be appealed to the state Supreme Court. The process, again handled by Butler, began anew. On May 5, 1999, the Supreme Court of the state of Alaska issued the following order. On consideration of the petition for hearing filed on 4/22/98, the response filed on 8/10/98, and the reply to the response filed on 8/24/98, it is ordered. The petition for hearing is denied. Kirby D. Anthony, sooner or later, will die in prison. Perhaps illness will afford him early release, or an inmate may terminate Anthony's sentence with the swift thrust of a sharp blade. Maybe he'll grow old, wear out, and pass away, a life luxury never experienced by Nancy, Melissa, or Angie Newman. Whatever his end, the odds of reformation or rehabilitation are beyond slim. The crux of the issue, observed Dr. Hare, is that psychopaths don't feel they have psychological problems. They don't see any reason to change their behavior or conform to society's standards. In fact, he has elaborated, they see themselves as being in a hostile dog-eat-dog world. They are not fragile. What they do comes from a personality structure that is rock solid. They understand the difference between right and wrong, said Stanton Samenow, a clinical psychologist from Alexandria, Virginia. And they understand the consequences to themselves and to others. That's not their problem, according to Same Now. What defines the violent antisocial personality of someone such as Kirby D. Anthony is a chilling capacity to shut off fear and knowledge of the consequences for as long as it takes to do what he wants to do. Numerous studies have found that if children continue disruptive behavior past ages 5 or 6, if they fail to learn the give and take of childhood play, and if they insist on dominating others at any cost, they are highly predisposed to become violent adults. While politicians, sociologists, and talk show commentators debate the causes of violent crime, medical researchers have increasingly argued that people who commit such senseless and horrid acts have distinct biological and behavioral characteristics. Individuals with strong antisocial personalities consistently show low levels of the brain chemical serotonin, which functions as both a neurotransmitter and a hormone. I don't think anyone disagrees that there are biological factors, said Professor Frederick Goodwin, who directs George Washington University's Center on Neuroscience, Medical Progress, and Society. We have clear biological explanations for why individuals do certain things. Both Goodwin and Same Now emphasized that inherited factors alone don't make someone violent. In fact, while most violent offenders have low serotonin levels, not everyone with a low serotonin level is violent. They also agree that even those who exhibit antisocial tendencies into adolescence can often be reached with counseling and sometimes medication. The true psychopath, however, is far more than antisocial and does not respond well to counseling. According to Dr. Hare, most troubled kids can certainly be helped by counseling, but not psychopaths. Most therapy programs don't do much more than give them new excuses for their behavior and new insights into human vulnerability. Further, psychopaths tend to dominate individual and group therapy sessions, refuse to talk about things they don't initiate, don't like to be confronted or questioned, and utilize long-winded monologues intended to circumvent discussions about their behavior. "Oh, that's Anthony, all right," said Grimes. "He was always furious with us for questioning him, and his 3-hour monologue certainly qualifies as long-winded." According to Hare, attempts to teach psychopaths how to really feel remorse or empathy are doomed to failure. They are also a rich source of excuses, such as, "I never learned to get in touch with my feelings," which explain very little but sound good to some counselors who are willing to accept such statements at face value. A profound inability to experience empathy and the complete range of emotions, including fear, is provided by nature and perhaps by some unknown biological influences. As a result, the ability to develop all-important internal controls, conscience, and for making emotional connections with others is gravely reduced. We do not know exactly why people become psychopaths, Hare has stated, but all current evidence discounts the notion that poor parenting is the primary reason, although it certainly doesn't help matters. This does not mean the parents and the environment are completely off the hook. "I spoke at length to Kirby's brother," recalled Detective Baker, "and he told me how horribly Kirby was treated by their father, the beatings and all. Despite Peggy Anthony's sincere and heartfelt efforts, she could never compensate for the horrific acts perpetrated against her youngest son by her violent and abusive husband. When he was done telling me how bad it was, I said, 'That's the recipe for making a monster.' He said something like, 'Bullshit. I was raised the same way, and I've never killed or raped anyone, let alone members of my own family.' Childhood is no excuse," Kirby Anthony told the court during his trial. "That's one of the pathetic things they've always tried to relate to crimes on people like this. If they were brought up bad, you know?" "I think there's something wrong with Kirby Anthony's brain," stated Detective Spatafora. "Some sort of mental birth defect for which there is no cure. A tragic combination of defective nature and perverted nurture created a monster. Kirby Anthony is the best argument for reinstating the death penalty in Alaska. The death penalty was invented for guys like him. I know plenty of people are opposed to the death penalty, and I can understand their objections. But if innocent lives can be saved by sending mother rapists and baby killers to their eternal lack of reward, I'm all for it. Anthony's living victims, John Newman, Cheryl Chapman, and their intertwined extended families, will never fully recover. Nancy was John's very first woman, the love of his life. They had 2 beautiful little girls, both adored and loved. John Newman's therapist advised him to buy a punching bag. By the time the trial was over, he had broken 2 and was almost ready to replace the 3rd. Every day was, for John Newman, a fight to survive. He couldn't work nor think straight, despite his best efforts. His only hope was that perhaps someday in the future, the horrible emptiness, repulsive loneliness, terrible rage, morbid dreams could be replaced by a life that had even 1/10 of the joy his family brought him. When the numbness and shock wears off, the living victims experience certain emotional, physical, and spiritual reactions, all of which are normal, said Dr. Rubin. Feeling anger at God, questioning your belief system, searching for answers and meaning in life and death. These are the common spiritual reactions. The physical, emotional, and mental reactions can be, however, the most immediately devastating. Emotional reactions may include crying, hysteria, anger, sadness, guilt, loneliness, helplessness, acute suffering, withdrawal, unresponsive emptiness, hopelessness, despair, panic, depression, isolation, separation anxiety, bitterness, self-pity, resentment, and abandonment. All these reactions, to one degree or another, were experienced by John Newman, Cheryl Chapman, and their families. For John Newman, the loneliness was difficult beyond expression. In addition to the emotional anguish, the body is also strongly impacted by grief. Among the numerous symptoms are numbness, tightness in the throat, difficulty breathing, pain or tightness in the chest, nausea, fatigue, inability to sleep, blurred vision, headaches, glandular disturbances, lack of muscular strength, a feeling of emptiness, loss of interest in sex, dizziness, and a decreased resistance to illness. Mental reactions encompass confusion, decreased self-esteem, lack of concentration, denial, loss of control, insecurity, disorganized thinking, regrets, hostility, searching for the deceased, thinking you are going insane, thinking constantly of your loved one, thoughts of dying, and dreams of the deceased. Plagued by unceasing nightmares, John Newman thought many times of taking his own life. He had lived with and deeply loved Nancy Newman for 14 years, and suddenly she was gone. His beautiful little girls were also taken from him. It's impossible to describe the terrible hurt and loneliness that John Newman was compelled to endure. For Cheryl Chapman, the pain of losing her sister and nieces was overwhelming and devastating beyond description. She gave up her job at Gwenny's. She couldn't go back, because she would always expect to see Nancy walking out of the kitchen with an armful of orders. Heartbroken and distressed, Chapman and her husband left Alaska. They could not bear to live in Anchorage or drive by Nancy's apartment. Everything was a constant reminder of going there Sunday morning, March 15th. The geographic change did not relieve the mental and emotional anguish. The impact on their marriage was irrevocable. Cheryl Chapman had a problem relating to men after the murder and could not stand the thought of a man's touch. The Chapmans separated 2 weeks after moving to the lower 48. Cheryl moved in with their brother Tom in Twin Falls, Idaho, but could not find work. She then moved to Nevada and stayed with her brother Donald and secured employment. 6 months following the murders, she would still panic and relive everything all over again. She couldn't take a shower home alone or sleep in a room with the door closed. A year after the tragedy, she had overcome many of the symptoms, but still could not stay by herself at night. It took John Newman 4 hard years to rise above the drowning undertow of grief and depression. Day by day, week by week, month by month, John Newman, with the love and support of his close-knit extended family and compassionate professional counseling, gradually recovered his life, his future. Today, more than a decade after experiencing the most devastating tragedy imaginable, John Newman, recently remarried, is in excellent physical, mental, and emotional health. Afterword and author's comments, updated 2016 for ebook and audiobook editions. When I received the contract for Murder in the Family, fellow true crime authors Gary C. King and Jack Olson gave me wise advice. "Be prepared to cry," said King. "Be prepared to have nightmares." There is nothing, however, that can prepare anyone for the horrific acts of cruel brutality committed against Nancy Newman and her 2 adorable daughters by Kirby D. Anthony. Jack Olson insisted that any true crime book that doesn't explore the life and mindset of the perpetrator is simply pornography. I was determined to tell the story with honesty, integrity, and, as much as possible, with insight into the mind and motivations of the psychopath who will live out his life far removed from any potential victims. The week Murder in the Family was released, I received a telephone call from Kirby Anthony's newest attorney. "Did you write this book because you believe Kirby is innocent?" "No," I told her. "We selected the case of Kirby Anthony precisely because he's so damn guilty." Awaiting trial, Kirby continued telling other people with whom he was incarcerated that he was sure to be free. "They got nothing on me," he insisted. "I'll never be found guilty." They had plenty on him, and he was guilty as hell. No one wanted anything to do with him, recalls a former fellow prisoner who met Kirby at the Cook Inlet facility for individuals awaiting trial. We all knew what he was accused of, and his entire attitude was so ice cold. It was as if there was no emotion to him. Anyone who was accused of such a horrible crime and they didn't do it would be an absolute desperate emotional wreck. Not Kirby. The sickening nature of the crime didn't seem to bother him at all. But I'll tell you that there are plenty of people in prison, murderers and rapists themselves, who have no sympathy for someone who rapes and murders children. Those guys would gladly rip Kirby Anthony to shreds. Emotionally shredded was Debbie Heck, who couldn't help but condemn herself for implied tangential culpability. When Kirby killed Nancy, Melissa, and Angie in a murderous rage, Debbie was most likely the sublimated target of his perverse and deadly behavior. Kirby, of course, would deny any such inference and would remind us that he devoted much of his rambling closing argument to the recitation of love poems composed for Debbie Heck. Once the trial was over, Debbie did her best to rebuild her life and build walls around any recollection of the Alaskan tragedy. When she read Murder in the Family, her walls of denial and emotional distancing collapsed, awakening her in the middle of the night and leaving her awash in horrific memories. "At first," she admitted to me, "I told myself that the things you wrote about me in the book weren't true, that you made them up. But you didn't. It's all true." Debbie Heck agreed to join me for a live television interview by Kent Phillips on the Emmy Award-winning talk show Northwest Afternoon on KOMO-TV in Seattle, Washington. I first met Kent Phillips in 1980 when he was a recent Whitman College graduate working at KUJ in Walla Walla, Washington. I was honored when Kent asked my professional help and guidance in preparing the audition tape he used to launch his brilliant career. I hadn't seen Kent face-to-face since we finished producing that tape in 1980. Being his guest on a tremendously popular television program with Debbie Heck by my side was validation of my first positive impression of Kent Phillips decades earlier, and proof that a sensitive and caring woman traumatized by a murdering psychopath can seek and achieve closure. Well prepared, Kent coaxed from Debbie Heck compelling and heartbreaking details of her relationships with Kirby Anthony. Debbie is one of those rare sensitive human beings whom I can best describe as having her soul on the surface. I doubt she could ever lie, for her expressions tell everything. Her remarkable emotional transparency is endearing and engaging, revealing both remarkable strength and genuine vulnerability. At one point, a videotape of the trial was played for the television audience. In the selected scene, we watched Debbie in the courtroom listening to Kirby, on the verge of conviction for the rape and murder of his aunt and her 2 little children, proclaiming his undying love for Debbie Heck. "How does it make you feel to see that?" asked Phillips. Debbie paused before answering, a pause so filled with pain and vulnerability that the audience held its breath. "Haunted," she replied softly, a slight tremble in her voice. "I feel haunted." Everyone, including the show's host, fought back involuntary tears of empathy. "I had to do this," she told me after the show. "I couldn't pretend it never happened. I wanted closure. I needed closure. As for Kirby, he is closed off from society, and there's no danger that he will rape or murder anyone else, although his name has cropped up in 2 news stories of minor interest, one concerning the prison issue of Mutual Combat and the other involving a bomb scare evacuation. Mutual Combat. Kirby Anthony was placed in disciplinary segregation as punishment for engaging in mutual combat with another prisoner, Fernando Jimenez. Eric Nielsen, a maintenance plumber, witnessed and reported the altercation over the radio and later described the altercation in an incident report. Anthony disputed the incident's description, insisting that he did not engage in any combat, mutual or otherwise. Both Anthony and the other inmate were taken away in hard restraints and placed in administrative segregation. Anthony requested that the security video footage from the kitchen at the time of the altercation be saved for viewing by the disciplinary committee, but the footage was not even looked at, let alone saved, and then was erased. Anthony was charged with the high-moderate infraction of mutual combat, but pled not guilty. At the hearing, Anthony presented his story of the altercation, insisted that the security video would have verified that story, requested that inmate Michael McCullough testify on his behalf, and requested leniency. The disciplinary committee ignored those requests and found Anthony guilty of mutual combat and sentenced him to 30 days of punitive segregation. Even a heartless psychopathic baby raper and child killer such as Kirby Anthony knows when he's getting screwed by those supposedly dedicated to justice and penitence. It is one thing for criminals to do it and be punished for it. It is quite another for the standard bearers of justice to do it and get away with it. The Superior Court, being superior in more than just title, had no difficulty recognizing that failure to call a witness, failure to admit the video footage along with failure to explain what happened to that footage, failure to even list what evidence was used to find the prisoner guilty, use of an incorrect definition of mutual combat and reliance on hearsay. Anthony also claimed the state knowingly and intentionally violated his rights. He requested amendment of his disciplinary record, reinstatement to the position he occupied before he was found guilty, and lost wages. Anthony prevailed. They even paid him over $400 in lost wages while being in punitive segregation. This doesn't mean that Kirby Anthony is a really nice guy. It just means that the prison was not following established laws and procedures. Just because you are a criminal does not mean you can be treated in an unjust and criminal manner. The second news item about Kirby since the trial is admittedly weird and more consistent with his erratic mindset. On May 21, 2013, a woman received a package from Kirby Anthony. She had no idea who he was or why he would send her a package. She did a web search and discovered his horrid history. She called the cops, who sent in a bomb squad to X-ray the package. Inside were wires, a light bulb, and a clock. Yes, it sure looked like a bomb. At that point, we had to back up and treat it as an explosive device, said a police spokesperson. The bomb squad did what they normally do, which is to utilize a device. Essentially, it's a water device to blow up the package and render it safe. Authorities were forced to evacuate several homes immediately surrounding where the package was found, as well as homes along the same side of the street. The evacuation lasted about 30 minutes. Authorities were unable to figure out for what reason Anthony sent this woman a box containing a clock and a light bulb, a gift neither timely nor illuminating. And there was no further information released regarding this incident. The Newman family and the Anthony family are forever scarred by the murder of Nancy and her two beautiful daughters, as is Debbie Heck. Such scars never go away, but life is for the living, and life goes on. One of Newman's close family members, Shailene Eastman, was initially upset by the publication of this book and shared her negative comments online. While I could understand her personal pain, her remarks saddened me. Later, she changed her mind. After giving more thought to this, she wrote, I realized that the author was just telling the story and not making judgment or light of the incident. Therefore, I would like to let him know it was very well written and thank him for keeping my family members real people. That change of heart and the compliment offered meant the world to me, and I wish to publicly thank Miss Easton, herself a crime scene analyst in Arizona, for her most gracious comments. Important considerations. In 1999, a series of tragic events focused America's attention on teen violence and antisocial behavior. Congress funded extensive studies of video games. Airlines edited gunfights out of in-flight movies. And the season finale of television's Buffy the Vampire Slayer was pulled from broadcast because it featured scenes of high school violence. Seeking external motivations for irrational acts, placing blame became a national pastime. Movies, music, working mothers, poor parenting, electronic video games, lack of compulsory Christian prayers in public schools were all viable scapegoats. The United States Congress's investigation of video games was not dissimilar to the 1950s investigation of such pop culture publications as Tales from the Crypt and Mad magazine. Televised reruns of old Popeye the Sailor cartoons once came under attack for his spinach-fueled fisticuffs, and the Three Stooges' slapstick antics prompted concern that America's next generation would slap themselves silly while poking out each other's eyes. In the final analysis, blame is only important to drunks and litigants. What we really need is an early warning system, a method of identifying psychopaths and sociopaths before adolescence, and pre-puberty intervention. Psychopaths begin showing up in court at the average age of 14. Once they reach adolescence, reversing the condition is impossible. Childhood intervention, however, can make a significant difference. Most of the children who end up as adult psychopaths come to the attention of teachers and counselors at a very early age, Dr. Hare has stated. It is essential that these professionals understand the nature of the problem they are faced with. If intervention is to have any chance of succeeding, it will have to occur early in childhood. In the case of Kirby D. Anthony, it doesn't take a federal study to grasp his life's sadly predictable trajectory. In 2020 hindsight, we see psychopathy's symptoms from his earliest childhood. This is a personality disorder, Dr. Hare has explained, not simply some specific behavior such as stealing or aggression. No diagnosis is free from error or misapplication by careless or incompetent clinicians. On the other hand, failing to recognize that a child has many or most of the personality traits that define psychopathy may doom the parents to unending consultations with school principals, psychiatrists, psychologists, and counselors in a vain attempt to discover what is wrong with their child and with themselves. It may also lead to a succession of inappropriate treatments and interventions, all at great financial and emotional cost. Dr. Hare's psychopath checklist, used to identify possible psychopaths, is a complex tool for professional use only. Do not use these symptoms, Dr. Hare has cautioned, to diagnose yourself or others. Psychopathy is a syndrome, a cluster of related symptoms. It is important to obtain an expert opinion. Seek the advice of a qualified, registered forensic psychologist or psychiatrist. Key symptoms of psychopathy: emotional, interpersonal, glib and superficial, egocentric and grandiose, lack of remorse or guilt, lack of empathy, deceitful and manipulative, shallow emotions, social deviance, impulsive, poor behavior controls, need for excitement, lack of responsibility, early behavior problems, adult antisocial behavior. Screening preteen children for symptoms of psychopathy is more practical, effective, and difficult than restricting video games, editing movies, or canceling television programs. Accurate psychological diagnoses involve more complexity and responsibility than composing editorials against goth fashions, professional wrestling, pinball machines, or garish rock bands. For the first time in history, we have diagnostic tools that may help avert tragedies such as the Newman homicides, the rape of Michelle Bethel, and the brutal murder of Walter Napagack. Prevention, of course, is preferable to diagnosis. The key to prevention may involve both nature and nurture. Through medical research, the specific brain disorder or defect may be identified, treated, or corrected, perhaps even before birth. The nurturing aspect would certainly involve a violence-free family. It's my opinion, said State Trooper Jim Farrell, that striking, hitting, and berating a child causes their soul to recoil, and that repeated beatings and insults completely and irrevocably pervert their character. If all children, whatever their disability or handicap, were raised in an atmosphere of love, respect, courtesy, and kindness, we would see a significant reduction in violent crime. I realize that psychopaths can come from good families, but worse families give us worse and more violent psychopaths. Psychopaths from unstable backgrounds commit many more violent offenses, agreed Dr. Hare. This is consistent with my suggestion that social experiences influence the behavioral expression of psychopathy. A deprived and disturbed background, where violence is common, such as in the upbringing of Kirby Anthony, finds a willing pupil in the psychopath for whom violence is no different emotionally from other forms of behavior. As previously explained, psychopaths lack the capacity to experience emotions. It is the emotionally charged thoughts that give bite to conscience and account for its control over behavior. This bite of emotion generates the sense of shame, guilt, or remorse. Psychopaths simply cannot understand these emotions because they are incapable of experiencing them. For them, Dr. Hare has stated, conscience is nothing more than awareness of rules created by others. Empty words, dramatic, shallow, and short-lived displays of feeling are, for example, a behavior trait of psychopaths. Careful observers are left with the impression that they are play-acting and that little is going on below the surface. Don't look to the cops to solve the problem of criminal psychopaths, said Mike Grimes. By the time police are involved, it's too late. The homicide has already happened. Society spends millions prosecuting, incarcerating, and supervising convicted psychopaths. More jails, more laws, more police. These are not going to cure psychopaths, nor deter them from violent behavior. Locking them up keeps them away from innocent people, protects potential victims, and saves lives. In the long run, if the public is to be truly protected and their best interests served, an effective treatment or preventative for psychopathy must be either discovered or devised. Acknowledgements. I extend thanks to the detectives and officers of the Anchorage Police Department, past and present, for their kind cooperation. The same thanks are extended to the officers and investigators of the Twin Falls, Idaho Police Department. Another measure of appreciation goes to exceptionally cooperative staff of the Alaska court system: Bill Ingaldson, John Salemi, Jim Farrell of the Sex Offender Central Registry Unit of the Alaska State Troopers, Carol Hawkins, and Dr. Robert Hare. Materials from the published works of Dr. Hare are used with his kind permission. Husheng and Movafak took me into their home and hearts while I conducted research in Anchorage. I thank them for their hospitality. I also wish to acknowledge Mr. Douglas Martin and the 8 other gentlemen with whom he consults, who took time from their pressing obligations to offer me prayerful support. Gratitude is also expressed to Charlotte Dial Breeze. If not for her creative financing techniques, researching this book would have been impossible. Karen Haas, one of the finest editors since the invention of editing, was absolutely brilliant. The mass-market paperback edition of Murder in the Family is available from Kensington Publishing Group's Pinnacle True Crime imprint. The electronic downloadable version for your e-reader is available from Wild Blue Press. The audiobook version is produced by listenupaudiobooks.com. Everyone involved has done their best professional work to provide Murder in the Family in the manner, format, and media you find most convenient. This has been a Listen Up Audiobooks production of Murder in the Family, written by Burl Barer, narrated by James Edward Thomas, executive producer Chris Fogg, production supervised by Greg Cooler, copyright 2016 by Burl Barer, production copyright 2016 by Listen Up Audiobooks.